As a legal anthropologist, I must say that I have to also acknowledge and recognize the fact that the Delhi High Court did support or did give permission and extend its kind of support to this research. And I think it's extremely important that courts recognize the value of socio-legal research, especially the importance of courtroom ethnography. And the PLD study reminds us, and various friends who are also legal anthropologists are here, of what Roscoe Pound called the distinction between law in books and law in action. And the idea that no law reform can succeed by grand narratives of change, and that we need to bring thick and fine-grained empirical understanding of legal processes in order to bring about any kind of change, also as Rebecca just reminded us. Also this, inordinate attention on sentencing and outcome, is conviction, 10 years, 20 years, death, etc. Sort of, we need to shift our focus from that to everyday practices of the law, because even if you get a conviction, you may be completely traumatized by the legal process, right? So in a certain sense, one needs to, as PLD has done, and some of us have done in our own work, look at every stage of the pre-trial, the trial process, and in the aftermath of the trial, to look at perspectives that engage with the life worlds of victims and survivors. Now, one of the interesting questions which this report poses is this question of methods and how does one research sexual violence. And the question of one of the things which I've really think is important is this question of informed consent of victims, and that it inevitably means negotiating with the family, right? So women, so consent is heavily mediated by the family, and the voice of the woman is often made opaque by a plurality of contexts. And I think we need to have greater conversations on our experiences as researchers and the question of how how women negotiate patriarchal contexts in order to, I don't know whether your experience of your researchers was that, sometimes conversations with strangers can be therapeutic for people in court, because nobody's talking to them, right, sympathetically or empathetically about their experiences. Sometimes it can create an unsafe situation. So the conversation, I found the methods part of your report interesting. Also, as Madhu said, that I found this too in my work in Gujarat, that often survivors and victims are forced to move out of neighborhoods after they complain, or that there is a huge pressure, and I found that especially true in my study. I don't think it's that central in the PLD study, is the pressure to compromise. So compromise often acts, it's there, but as a technique of terror. Especially when the rape accused exercises social, economic, political, or religious dominance over the victim, which is where PLD makes another interesting contribution, where it looks at, it unpacks the NCRB data on, this category of the victim, what is it called? The accused, rape by people known to the victim or acquaintance rape. I like the way in which this report unpacks this category, because otherwise this thing known to the victim, it always sort of, the impression is that it's a neighbor, friend, or a partner or a relative, right? It's some kind of intimate partner violence, something of that sort. But actually, if you look at their analysis, the men who rape women are often in a position of dominance as employers, debtors, or agents. So acquaintance rape is also often about economic, political, and custodial power over women. And the other startling finding is that many of these men repeatedly rape the same woman. So if you have been incarcerated, you come back and rape the same woman, or you might have raped other women. So this thing about repeat offense, I think those two findings are very important. The strategy of this study, the methodological strategy, is to look at how the legal identity of the victim changes at different sites. So the victim may or may not be a faryadi or a complainant at the site of the police station. She's a patient at the hospital. Her body is reduced to a sample for the forensic lab. Her clothes become muddabal. Her story becomes deposition. And she's characterized as a legal witness, as a witness and a victim. She's characterized as a prosecutrix. Now, if you look at the genealogy of the word prosecutrix, and I know all my legal friends prefer using this word prosecutrix, but if you look at its genealogy, it literally means a female prosecutor who persecutes, because the word prosecutrix used to appear in the past sexual history clause, right? So the distinction between prosecution and persecution is blurred by this word prosecutrix. So one of my questions is whether we can think of other forms of naming the legal subject who's both a victim and a witness, and abandon the language of prosecutrix. Now, of course, some things have changed, but yes, I agree, a lot needs to be done. And one instance is in the field of medical jurisprudence. And Madhu sort of, the PLD report confirms that this attempt to change this culture where this medicalized culture, as it were, where consent has been medicalized. So you read consent of the woman's body through the two-finger test, characterize her as a habituee, etc. That kind of expert culture requires to be displaced, and it cannot be displaced so easily through simple issuing of guidelines or even training. Right? And while there has been a revolutionary change in Modi's medical jurisprudence, in part facilitated by Mrinal and Justice Kannan and the work of Sehat, but there's a lot more work which needs to be done, especially in the realm of pedagogy and production of textbooks, right? Because these are the textbooks which actually structure the kind of questions which are asked in the courtroom. So whatever is written in Modi, if they aren't reading the latest version and it's not part of their vocabulary, they'll use that language in order to cross-examine the victim. So there is that kind of traffic of categories between the two. The other very important aspect of the PLD study, which hasn't gained much attention in law reform discourse, is about the seizure of clothes for forensic analysis. So the study points out that even if you're not wearing the same clothes and you go sort of 15 days, 20 days later to file a complaint, they still seize your clothes, right? But we haven't really. Vasudha Dhagamba pointed this out in the 1980s, that the police or the hospital seizes a woman's clothes without giving her a spare set of clothes. So, I mean, does the law expect women to carry an extra set of clothes when they go to complain in a police station or in a hospital? And I think this, and in other countries, you are provided extra pair of clothes, etc. So I don't think this is a small issue. And it has never really become part of any campaign. So while we have focused on the two-finger test, similarly, we haven't quite focused on the kind of indignity somebody like Bhavri Devi went through. She had to wear her husband's turban or whatever. So one needs to, in a certain sense, take up this issue as well. In terms of support, of course, the PLD report points out that one needs counseling of both the victim and her family, but this counseling has to be empathic rather than sympathetic, or one which is based on compassion rather than pity, and which has a certain kind of framework of understanding towards sexual violence, because not all forms of counseling are victim oriented, and in a certain sense you don't want, care can also be a form of violence if one doesn't challenge mainstream categories of counseling and care. The PLD report also makes the valuable recommendation that women should be given medical treatment for rape, irrespective of whether or not they complain to the cops, right? So you cited Canada, where they actually store, the samples and the evidence for 6 months. So you have time to decide whether you want to go to the cops or not. So a therapeutic, what the, for example, in the US, you have a branch of specialized nursing for sexual assault. So we need to put in some energy in developing a different kind of therapeutic what is called therapeutic jurisprudence, wherein victims are treated with care and dignity without compromising the rights of the accused. And the courts can play an important role in bringing about this transformation. However, empirical legal research must inform reform, I think. And the critique of mainstream legal cultures must be allowed to flourish. So we shouldn't have to feel so scared of or threatened by the specter of contempt.